In this lesson, what I want to do is talk more about the crime of theft. And we're going to talk specifically about the idea of deprivation of property, the intent to permanently deprive. This is, of course, a requirement, a final mens rea requirement for the definition of theft. In fact, this is the final lesson that we're going to do on the subject of theft. And really, this is covering section 6 of the Theft Act, which, of course, talks about this idea of an intention to permanently deprive. So we're not going to be finished completely with these principles, because when we start looking at fraud, you will notice that there are a lot of similarities between the two offences. Theft and fraud are both dishonesty offences. They both require this element of dishonesty. So you shouldn't just forget about theft completely. The idea of dishonesty in relation to fraud is the same as the idea of dishonesty in relation to theft. So don't just completely ignore or completely give up on your understanding of this particular topic, because you have to think about it again when we get looking at fraud. In addition, if you are a member who has access to the exclusive lessons on the topic of criminal damage and other property offences, such as burglary, robbery, as well as making off without a payment, these also require you to have an understanding of theft as well, because they have elements of theft attached to them, but that they also have other parts that essentially delineate themselves from a basic standard of theft. So bear that in mind for everyone who is watching these videos, whether you are a member or not. So this is the final part of the consideration of theft in relation to the criminal law. And as a basic recap, we know that theft has been the study of the dishonest appropriation of someone else's property with the intent to permanently deprive. We notice as well that the red highlight here is the mens rea. The blue highlighting here is the actus reus. So mens rea encompasses the dishonesty part, as well as the intention to permanently deprive part. The actus reus refers to the appropriation part, as well as the appropriation of somebody else's property. The definition of the law itself is property belonging to another. We've already talked about all of those different elements. We've talked about what dishonesty means. We've talked about what appropriation means. We've talked about what property is defined as in the legislation. And we've also talked about this idea of property belonging to somebody else. And as noted and as made very, very clear, the last part of this is the final mens rea element, which is, of course, the intention to permanently deprive another of their property. Let's get into this then. Intent to permanently deprive. Really, this is quite difficultly established in Section 6, subsection 1 of the Theft Act from 1968. Now, it's not the easiest piece of legislation to actually understand, and rather, in fact, some of the textbooks, especially the Herring Revision Guide, in fact, note that you should probably not even bother thinking about this element. Just take intent to permanently deprive as its original meaning, as its ordinary meaning within ordinary English. Because this definition is quite complex. So Section 6, subsection 1 says that, quote, a person appropriating property belonging to another without meaning the other permanently to lose the thing itself is nevertheless to be regarded as having the intention of permanently depriving the other of it, if his intention is to treat the thing as his own to dispose of regardless of the other's rights, and borrowing and lending of it may amount to so treating it if but only if the borrowing or lending is for a period and in circumstances making it equivalent to an outright taking or disposal. Quite difficult to really unpack. And so I can understand why authors like Herring, who've got their own textbook and who've got their own revision guides on this topic, who are cited down below, in fact, as one of the citations and or further readings, why they say that if you have a problem question relating to theft, unless it is a problem question that is specifically talking about, or the main issue is specifically about an intention to permanently deprive, try and don't get stuck into the weeds with section 6 subsection 1, rather just take intent to permanently deprive as you would ordinarily understand it, given its ordinary meaning in English, because that's there or thereabouts essentially what this piece of legislation does, but it does so in a very, very roundabout, very, very convoluted way. And we can illustrate this point by looking at the case of Crown and Floyd from 1985. This case was one in which we have a defendant who had been an employee at a cinema. They had the role of chief projectionist. This is 1985, so it's a little bit old days kind of employment jobs and all these different kinds of things. They were the chief projectionists. They did all the projecting of the movies onto the cinema screen. The defendant was working with two others, and they decided that they would take out movie tapes and hand them on to other defendants in order for them to make copies of the movies and then sell them on. So not particularly ethical, regardless of whether or not this is theft, not a particularly ethical thing to do. Now, the defendants, very importantly, the defendants would bring those movie tapes back and put them back where they were found. So the question here is, does this fall into the requirement for intention to permanently deprive? Well, given the fact that the defendants bring the movie tapes back, how can this be permanent deprivation? Well, he was convicted of theft at trial level, but then the Court of Appeal overruled this judgment on the basis that there was actually this lack of intention to permanently deprive. It was held that essentially the returning of the property may only amount to an intention to permanently deprive if there has been a loss of the, quote, goodness, virtue, or practical value of the property in the time in which it was taken. So what this is really pointing to here is that you could take property and then bring it back, and it could still amount to theft, owing to the fact that it could still amount to an intention to permanently deprive, but only if the deprivation is of the goodness, virtue, or practical value of the property at the time that it was taken. So if they had taken it out and then they had maybe destroyed the tapes or crushed the tapes up and then brought the tapes all broken back, theoretically, they could argue, well, I've brought the movie tapes back, so I have not intended to permanently deprive. But it may have been the case that this was a deprivation of the goodness, virtue, or practical value of the property. And so when we say intent to permanently deprive, it doesn't necessarily mean an intent to take something away and not give it back. It could also be characteristics of the property that have been permanently deprived that could therefore represent an element of theft for the purposes of the legislation.